The other applicants, Joseph Kuria, Irungu, Elias Jowie, and Jacqueline, you can sit, Maribe, are charged with the offense of murder contrary to Section 203 as read with Section 204 of the Penal Code. I've quoted the particulars. On 9th day of October 2018, they both appeared before the CJ, who deferred their plea taking to the 15th of October to enable the second accused to undergo mental assessment. They took their plea on the said date, and a plea of not guilty was entered in their favor. The accused persons thereafter made an application to be supplied with witness statements and documents the prosecution wished to rely on together with exhibits. They further prayed to be heard on bail under Article 49(1)(h). The prosecution in response undertook to supply witness statements, excluding those of the witnesses, to be placed under witness protection within 2 weeks, and indicated that they'll be opposing the bail application. In the meantime, the first accused had on 9th day of October 2018 filed an application and a certificate of urgency to be admitted on bail, supported by an affidavit sworn on the same day. The judge, Lesit J, then made the following orders: bail application to be heard before Wakiaga Justice, state to file and serve affidavits by 2 p.m., the victim's family to serve and file and serve their affidavits by 16th of October. The defense has leave to file and serve any responses. When the matter appeared before me for the purpose of fixing a hearing date for bail application, I made the following further orders: leave granted to the first and the second accused to file supplementary affidavits, the probation officer to prepare and submit to court pre-bail report including victim impact statement before the said date, the first accused to be treated at Kenyatta National Hospital through reference from the prison clinic, the media to guard against what they put in public domain now that this matter is before court. I've set out the history of this matter at the onset, since this matter has generated a lot of public interest, both in main and social media, and it is in the best interest of justice that the record speaks for itself, so as to put media speculations to rest. So I've gone through the affidavits sworn by each side, and I've quoted them in details. Then I've gone through your submissions one by one. You will read what I've said about what you people have said. Then I've struggled to also put my mark on the general principles for grant of bail, which I don't think you guys are interested in, but I've said there being no definition as to what constitutes. I've said that in Kenya, the legislature in its wisdom have not enacted bail legislation to determine how the issue of bail and bond should be dealt with. And to cure this gap, the judiciary has formulated a guideline through the bail and bond policy guidelines so as to bring uniformity on the bail, grant of bail, with the primary factor being whether the accused persons will appear for trial if granted bail as stated in Section 124 of the Criminal Procedure Code. There being no definition as to what constitute compelling reasons under the Constitution, the policy guidelines have set out under Section 49 what they consider difficult compelling reason. To this list, I would add that the court ought to look at the impact which the grant of bail might have upon the conduct of the case and the need to further balance between the liberty interests and interests of the accused person and the interests of society in denying bail. Once the prosecution shows on a balanced probability that there are compelling reasons, the burden then shifts to the accused person to rebut those compelling reasons or to show that there are exceptional circumstances to warrant his release on bail. And the court should always grant bail where possible and will lean in favor of and not against the liberty of the subject, provided that it is clear that the interest of justice will not be prejudiced. So I've quoted several cases so that I look a little bit learned. I've quoted several cases, but I've said that an immune attitude is required to be adopted by a judge while dealing with application for remanding a suspect or an accused person in custody. There are several reasons for this, including maintaining the dignity of an accused person, however poor or rich that person might be, since the grant or refusal of bail is entirely within the discretion of the judge hearing the matter. And though that discretion is unfettered, it's an exercise of a judicial function which must be done in humane and compassionate manner. All the authorities have been referred to by both the prosecution and the defense supports the prepositions which I've stated up here. I've read the same and I'll never bother to produce them because everybody knows them. So the next issue for resolution that needs to be determined at the threshold is how should the accused persons be treated while dealing with the application for bail. Mr. Katwa, for second accused, submitted that each of the accused persons be treated individually and separately as under Article 27(1) of the Constitution. Every person is equal before the law and has a right to equal protection and equal benefit of the law. While the first accused is silent on this point, Ms. Mwaniki for the prosecution admitted that the accused persons are jointly charged and must be treated as such. Article 49(1) talks of the right of an arrested person. Therefore, while dealing with the rights under Article 49H, in that each and every accused persons must be treated individually. This position is further justified by provision of Article 52, the right to fair hearing, which also talks about every accused person has the right to a fair trial, which includes right to be presumed innocent until the contrary is proved, to adduce evidence and challenge evidence, to refuse to give self-incriminating evidence. In the eye of the law, whereas the accused persons are jointly charged, each person is independent of each other and can choose to testify against each other and must therefore be treated as such, since the evidence which is likely to be tendered against them will not be uniform but based on the level of their involvement in the commission of the offense. They must therefore be treated as such, as the court is here dealing with a matter that requires great sensitivity. The stage is now appropriate for the court to look at each accused person's application against the material placed before me under each sub-headings of compelling reasons, identify the prosecution in the affidavit and rebutted by each accused persons in the affidavit. We'll start with the first accused. Is he a flight risk who is likely to abscond the jurisdiction of this court? The picture that emerges from the prosecution's evidence are set out here in above, and the pre-bail report of the accused is that is a male version of Slay Queen, which for lack of better terminology, I'll call a woman eater. He was living in the house of the second accused, driving the second accused car with no known source of income since 2017 when he provided security for some Jubilee politicians. His first known employment as per his affidavit was in Dubai, where he had been living between 2012 and 2017. It is in Dubai where he seems to have strong social ties. As well, there he managed to secure employment for 3 named persons, including his brother and a brother of his former girlfriend who was living in Buruburu before he left for Dubai. He is extensively traveled in Middle East as per his affidavit, and therefore can easily find support therein. The second accused in affidavit state that she does not intend to go back to the house where they were living as at the time of the arrest. Whereas the first accused has indicated that his siblings are likely to find him an alternative accommodation, there is no evidence placed before court to support this preposition. The accused has no known assets in the country save for an intention to set up a private security firm, and therefore find him to be with no fixed abode, lacking any deep emotional occupation or family ties in the country, and is likely to abscond should need arise. The mere fact that he is willing to surrender his passport is no guarantee that he cannot leave the country if he wishes. Would he interfere with witnesses? There is material placed before the court, though of a factual nature, that there are ongoing investigation and arrest to be made of a suspect who was allegedly with him at the scene of the crime. There is a material placed before the court to the effect that after the commission of the offense, the first accused destroyed or attempted to destroy material evidence, including an alleged piece of clothing which he had worn on the material day. The first accused is silent on this material. The first accused is known to the family of the victim, including a brother who has sworn an affidavit confirming that he is the one who introduced the first accused to the deceased. This is an allegation, once again, of factual nature, not yet tested by cross-examination. There is an allegation, once again, of factual nature, not yet tested by cross-examination, that the first accused has been positively placed at the scene by way of identification parade. And since the first accused is alleged to know the scene of the crime very well, I find that there's a possibility that he might know the identity of those witnesses, and there's a possibility of interfering with them. He has been portrayed in the public domain as a lover of guns and with access to firearm. Having undergone specialized military training, specialized security training, and acted as a private security officer in Middle East, and during 2017 general election, there is a real likelihood that if released on bail, that could create fear and intimidation on potential prosecution witnesses, as it would appear to them that a man with a gun or access to the same, whom they intend to testify against is outside there. In this holding, I find support in the decision by Justice Chiang in Republic versus Ahmed Mohamed Omar and others, High Court of Kenya at Nairobi, criminal case number 14, 2010, where the judge had this to say. I would only add that potential witnesses in murder case is similarly susceptible to humanity. He knows that if the evidence it tenders that might lead the trial court to convict the accused person, he also knows that if he did not testify, there were chances that this would lead to acquittal of the accused. Therefore, he is fully aware that if the accused could ensure that the witness did not testify, he might be tempted to do so in order to enhance his self-preservation. If the accused was granted bail and had access to gun, the potential witnesses might prefer to preserve his life by keeping away from giving evidence. By so doing, I'm not saying that the applicant would necessarily go out to threaten the witnesses. While that is a possibility, I'm also saying that the witness could become genuinely apprehensive about giving evidence against a person who had access to gun and who was moving around freely, quote and unquote. That picture emerges of the accused person. So if he's left at large, he might be able to create fear amongst the witnesses. Whether the first accused needs protective custody. The first accused is currently nursing a gunshot wound, which according to the prosecution is self-inflicted in an attempt to commit suicide, which according to the accused is an unfortunate incident when he was shot at. Whichever way you look at it, what comes out is that the accused person is someone under threat of danger, and whether the same has admitted that he would be able to provide for his own security, I find favor in the prosecution submission that is a man in need of close supervision, and that supervision can only be achieved under protective custody, where effective policing is possible. Whether the needs of accused person for specialized medical attention is an exceptional condition to enable the court granting bail. Whereas the accused submitted that he is in need of specialized medical attention in fulfillment of his constitutional rights under Article 43(1)(c) to the highest attainable standard of health, there is no material placed before the court to show that he is unable to obtain that specialized training while in remand custody. I further find that the need for specialized medical attention can be remedied by an appropriate order by the court should the need arise. Having taken into account the material placed before me, the submissions by the advocates for the first accused, the family and the state and the authorities in support of the said submission, which I've looked at in detail, I'm certified and find that the prosecution has placed before court strong and adequate compelling reasons to enable me deny the first accused the enjoyment of his constitutional right to bail, which I hereby do. The same shall remain in custody during the period of his trial. Having noted the health conditions of the first accused, I order that the same be treated at Kenyatta National Hospital, 3 friends from the remand prison clinic, and to confirm the said treatment has been accorded to the satisfaction of court, the first accused shall attend mention before the Deputy Registrar of this court once after every 21 days, at which date the medical officer treating him shall file an appropriate report on his progress.